Imagine filing a lawsuit only to find out the court has no power over the defendant. Case dismissed before it even begins. That's why jurisdiction matters. Let's make sure you never miss this on the MBE or MEE. Smarter Bar Prep starts here. Civil procedure, jurisdiction, and venue. Jurisdiction and venue are foundational. They determine whether your case can be heard and where. Understanding these early helps frame all civil procedure topics. Jurisdiction refers to the court's power to resolve legal disputes and issue enforceable rulings. There are two main types of jurisdiction: personal and subject matter. One focuses on the people involved, the other on the type of case. Courts need both personal and subject matter jurisdiction to proceed legally. Personal jurisdiction is about the court's power over the defendant, not just the case. Two requirements must be met. One, there must be a state statute authorizing jurisdiction. Two, it must comply with due process under the U.S. Constitution. A long arm is a state law that allows courts to assert jurisdiction over out-of-state defendants. The defendant must have sufficient ties or actions linked to the state. There are three main types of jurisdiction. General, where the defendant is at home. For individuals, this means their legal domicile, and for corporations, it's either their place of incorporation or where they operate their main business. Specific, when the claim arises from the defendant's activity in the forum, and jurisdiction by consent or waiver. Even if the court wouldn't have jurisdiction by default, you can give it power by agreeing or not fighting it. Due process means the defendant must have minimum contacts with the forum state. The contacts must be purposeful, not random, like doing business there, shipping products, signing contracts, and exercising jurisdiction must not offend traditional notions of fair play and substantial justice. Subject matter jurisdiction means the court can hear certain types of cases. In federal court, that's either because the case involves federal law or because there's diversity of citizenship, meaning the parties are from different states, plus an amount in controversy over $75,000, not including interest or legal costs. In federal courts, there are two main types: federal question and diversity jurisdiction. Federal question jurisdiction applies when the claim arises under federal law, meaning that if the claim is about a federal issue, the court has jurisdiction, but it must be clear from the complaint itself. It is also known as arising under federal law. Diversity jurisdiction requires complete diversity between plaintiffs and defendants and an amount in controversy exceeding $75,000. Citizenship is based on domicile, not residency. Domicile means more than where you live. It's where you intend to stay. If all parties are from different states and the amount is big enough, federal courts can hear the case. Complete diversity means that no plaintiff can be from the same state as any defendant. Just one overlap is enough to destroy federal jurisdiction. In this example, our plaintiff is from Florida, and the defendants are from Georgia and Florida. Because one of the defendants shares a state with the plaintiff, both are from Florida, complete diversity is lost. Sometimes, one claim has enough weight to get into federal court, but an additional claim doesn't. That's where supplemental jurisdiction comes in. Federal courts can hear a second claim that normally wouldn't qualify for federal jurisdiction if both claims come from a common nucleus of operative fact. Think of it like this. If both claims are so closely related that it wouldn't make sense to split them, the court can keep them together. If the original claim is based on diversity jurisdiction alone, then plaintiffs cannot use supplemental jurisdiction to add a non-diverse party. That would violate complete diversity. Even if a claim meets the test for supplemental jurisdiction, a court can still refuse to hear it, especially if the state law claim overwhelms the federal issue, or if the main federal claim gets dismissed early. Venue determines which court is geographically appropriate, where the case physically happens. In federal court, venue is proper where any defendant resides, if all defendants are in the same state, or where a substantial part of the events occurred. If no venue fits, than any district where the defendant is sub judice to personal jurisdiction. It's about fairness and convenience. Forum non-convenience lets a court decline to hear a case, even when jurisdiction and venue are proper, if there's a much more suitable court elsewhere. This usually comes up in international cases where key witnesses, evidence, or parties are located abroad. It's not a transfer, it's a dismissal, so the case can be filed in the better forum. Venue can be transferred for convenience or if originally improper. The new venue must still be proper and serve the interests of justice. Time for some memory hacks. Memory hack number 1. Need specific jurisdiction? Call D.A.V.E. He helps you decide whether the defendant's contacts are enough for the court to step in, even if they're not at home. D is for defendant's contacts. Did they purposefully reach into the forum state? A is for arising out of. Did the claim arise from those contacts? V is for venue must be fair. Is this a reasonable place to litigate? E is for evaluate fairness. Courts look at the burden on the defendant, the forum state's interest, and overall efficiency. Memory hack number 2. To remember the 2 main types of jurisdiction, think of the following. Personal jurisdiction equals people and permission. So think of P equals P plus P. Subject matter equals subject plus statute. Think of S equals S plus S. Now, let me give you some study tips. Study tip number 1. Jurisdiction is often the real issue, hiding behind procedural motions. Spot it first, then solve it. Study tip number 2. To easily visualize complete diversity in cases with multiple parties, sketch a simple diagram. Put all plaintiffs on the left with their states and all defendants on the right. Place a V in the middle for versus. Now scan across. If any plaintiff shares a state with any defendant, complete diversity is destroyed. For example, a plaintiff from Missouri sues a defendant from Indiana and another from Wisconsin. That's okay. Complete diversity exists. But if a plaintiff from Missouri sues a defendant from Indiana and another defendant from Missouri, diversity is destroyed. Let's solidify what you've learned with 5 quick flashcards. Pause and repeat if needed. Question number 1. What are the 2 requirements for personal jurisdiction? A long-arm statute and due process. Minimum contacts plus fairness. Question number 2. What qualifies a defendant as at home for general jurisdiction? For individuals, domicile. For corporations, place of incorporation or principal place of business. Question number 3. What are the 2 types of subject matter jurisdiction in federal court? Federal question and diversity jurisdiction. Question number 4. Where is venue proper in federal court? Where any defendant resides, or where substantial events occurred. Question number 5. Can a party consent to personal jurisdiction? Yes, through explicit agreement or by failing to object. That's it for today's video on jurisdiction and venue. If this helped clarify things for you, hit like, subscribe, and drop a scale emoji in the comments so I know you made it to the flashcards. In the next video, we'll cover law applied by federal courts. Don't miss it. And remember, you don't rise to the level of your bar exam dreams. You fall to the level of your study systems. So let's level up together.